I'd like to introduce our Constitution Day speaker this evening, and he is the noted Constitution scholar and legal affairs journalist, Jeffery Rosen. Jeffery is a professor of law at George Washington University in Washington, D.C. He's also the legal affairs editor of the New Republic. He's a graduate of Harvard College, summa cum laude, of Oxford University, where he was a Marshall Scholar, and at Yale Law School. He is an accomplished author, journalist, and law scholar. His essays and commentaries have appeared in the New York Times Magazine, the Atlantic Monthly, on National Public Radio, and in the New Yorker, where he has also worked in the past as a staff writer. He's the author of several works, several books, but most recently he's the editor of the volume Constitution 3.0, Freedom and Technological Change. And I can tell you that for my Simpson colloquium students in Sacramento, we had a really nice conversation about the way that technology is really changing our understanding of constitutional liberty and the First Amendment. He's named one of the 10 best magazine journalists in America by the Chicago Tribune, and is the nation's, quote, most widely read and influential legal commentator, also by the Los Angeles Times. So please join me in welcoming to Simpson College, Jeffery Rosen.
Thank you so much, Professor Simpson. Thank you so much for inviting me here. It is an honor to be here on Constitution Day. It's been a pleasure meeting with several of you today and getting to talk about my favorite topic, technology and the future of the Constitution. I'm so looking forward to our conversation tonight about the Roberts Court and the future of the Constitution. This is a time of dizzying change. Technology is transforming our constitutional values before our eyes. Just last week, we saw the remarkable spectacle of the Middle East being set aflame by a single video. And we realized that the people who were making decisions about whether that video would be taken down or would remain up were not the United States government, were not European governments. They were lawyers at Google and YouTube, who today have more power over free speech and privacy than any king or president or Supreme Court justice. So to understand the future of the Constitution, we have to think not only about what American judges and courts say, but also about what multinational corporations say. And that is transforming our constitutional debates in ways I want to explore with you tonight. But that's not to say that courts are irrelevant in these debates. Just last June, the Supreme Court handed down one of the most controversial and dramatic decisions in recent memory when, by 5-4 vote that surprised many observers, the court upheld the centerpiece of President Obama's domestic agenda, the Affordable Care Act. And the deciding vote was cast by Chief Justice John Roberts, who many had expected to vote with the conservatives, but who split the difference in a remarkably creative act of statesmanship and ended up upholding the Affordable Care Act. I want to begin by exploring with you why did Roberts vote the way he did? And what does that say about his vision for the future of the Supreme Court? And then I want to try to apply some of those lessons to the dizzying technological challenges that will confront us in the years ahead. So let's begin with the decision of John Roberts. This is a subject that has fascinated me ever since I had the chance to interview the Chief Justice at the end of his first term in 2006. I was writing a book about the Supreme Court for PBS, and Roberts is a PBS fan, so he agreed to sit down with me and spell out his vision of the kind of Chief Justice he wanted to be. And in this interview, he expressed frustration that some of his colleagues were acting more like law professors than members of a collegial court. He said, "Apologies to you, Professor Rosen, but law professors have made some terrible Supreme Court justices. They're too theoretical. They're too enamored of their own pet ideological theories, and they're not concerned enough about the institutional interests of the court as a whole." Roberts expressed concern that the court was handing down decisions by 5-4 votes along party lines, with 5 Republicans against 4 Democrats. He said that this could create an image of the court as a political body in a polarized age. Roberts said that he would make it his mission as Chief Justice to avoid these 5-4 partisan splits, that he would try to persuade his colleagues to converge around narrow, unanimous opinions, and to put the institutional interests of the court above their ideological agendas. In this vision, Roberts said he would embrace as his model his greatest predecessor, John Marshall. John Marshall was Chief Justice between 1803 and 1837, and he was famous for bringing conservatives and liberals together by persuading them to live together in the same boarding house. They would discuss cases over a hogshead of Marshall's favorite drink, which was Madeira. And all the justices would get buzzed. And all the cases were unanimous. Of course, there was the famous moment when the justices voted only to drink Madeira when it rained. Marshall looked out the window and said, "Our jurisdiction is so broad, it must be raining." Exactly. More unanimity and more Madeira. So this was the vision that Roberts offered to me. Chief Justice Marshall's ability to use temperament and collegiality to avoid partisan divisions. And Robert recognized the difficulty in this task. He said, "It's sobering to think that out of my 16 predecessors as Chief Justice, more than half have been failures. They've been unable to achieve this consensus." But Roberts said it was worth trying, and he would give it a shot and see how he did. All right, well, I was very impressed by Chief Justice Roberts in this interview. Some people thought I was too impressed. My wife decided that I developed a man crush on Chief Justice Roberts. Which is false, I'm sure he did. But I was rooting for him to succeed in this vision that he articulated. I supported it. And therefore, imagine my surprise when the term after we talked, this is 2007, far from a lot of narrow unanimous decisions, there were more divisive 5-4 decisions along party lines than at any time in the court's recent history. This was the term of the first campaign finance case, before the Citizens United case, of an important affirmative action case, of a case involving partial birth abortion. And the justices were sniping at each other in personal terms. Justice Antonin Scalia accused Chief Justice Roberts of faux judicial restraint, which may not seem that terrible to you, but that's kind of fighting words on the Supreme Court, faux judicial restraint. And Stephen Breyer, Justice Breyer, said that Roberts had distorted precedents in his affirmative action decision, and generally any hope of unanimity and consensus seemed very elusive. All right, well, that summer I got the chance to interview a few more justices, and I don't want to suggest that I spend my time hanging out with the Supreme Court, but a bunch of them were promoting books and they were sitting down with journalists. So I got to ask Justice Breyer, will Roberts succeed in his goal of avoiding 5-4 decisions? And Breyer looked thoughtful and he said, well, he can join more of my opinions. That doesn't sound good at all. And then I asked Justice John Paul Stevens the same question. Stevens retired last year at the age of 92. He was 89 when we talked. A force of nature. He spent 2 weeks of every term the court sat at a condo in Fort Lauderdale. He would send in his opinions by email. He swam in the ocean every day and played tennis. He was really in remarkable shape. But I said, is Roberts going to succeed? And he said, I don't think so. He said, we all respect him. We like him. He's extremely smart and personable. But people have very strong views around here. They're not going to change their votes over a hogshead of Madeira or something silly like that. So Stevens thought, no, he would not succeed in avoiding 5-4 splits. And as it happened, that was the summer, I think, of the Citizens United case, where the court struck down campaign finance reform, provoking a presidential denunciation. President Obama, at the State of the Union address, stood behind a podium, and the justices of the court were about as close to him as you, ladies and gentlemen, are on the front row there. And Obama denounces the justices and points at them and says, you're unleashing corporate dollars into the American electoral system. And Justice Samuel Alito shakes his head and says, not true, not true. And this goes viral on YouTube. And then someone asked Chief Justice Roberts, how did you feel during this exchange? And Roberts said, well, it felt more like a political pep rally than an occasion of state. And if that sort of thing continues, I'm not even sure we justices will go to the State of the Union. As it happened, most of them did the following year. Justice Alito did not. I think his office said that he had an important dentist appointment or something like that. But this set the stage for the remarkable healthcare case of 2012. And you'll recall from the dramatic oral arguments that took place last March. 3 days of oral arguments. The first time in 47 years that the court devoted so much time to a case. The central constitutional issue was, did Congress have the power to pass the health care mandate, which requires you to buy health insurance or to pay something which was alternatively characterized as a fine or a tax, and a lot ended up turning on exactly what you call it, a penalty or a tax. It was made more complicated by the fact that during the debates over the health care mandate, all of the Democrats stood up and said, this is not a tax. President Obama is not going to raise your taxes. All of the Republicans countered, it's definitely a tax. Your taxes are going to go up, vote against it. The moment that the ink was dry on the bill, just moments after President Obama signed it, both parties rushed to court and took the opposite position. All of the Democrats said, this is definitely a tax, and therefore justified by the taxing clause of the Constitution, which authorizes Congress to pass taxes. And all the Republicans said it's definitely not a tax, and therefore is not justified by the taxing clause of the Constitution. To make matters even more complicated, someone discovered an obscure bill which said that if it is a tax, then you have to refuse to pay it and take the penalty before you can challenge it in court, meaning that the lawsuit couldn't proceed until 2014. And the government lawyer, Solicitor General Don Verrilli, was in the awkward position of arguing that the mandate was a tax for purposes of being authorized by the taxing clause of the Constitution, but it was not a tax in the sense of being barred by this lawsuit that required the challenge to be deferred. And Justice Alito was very skeptical of this argument. The central focus of the challenge had been on whether Congress has the power to pass the mandate under its power to regulate commerce among the several states, to regulate interstate commerce. And the challengers to the act all said that this could not be authorized under Congress's commerce power because Congress has the power to regulate economic activity, but not economic inactivity. And the decision not to buy health insurance, they said, is a form of economic inactivity. Furthermore, they went on to say, if Congress does have the power to regulate economic inactivity, it can force you to buy other things you don't want to buy that are good for you, including health club memberships and broccoli. And this hypothetical, which became known as the broccoli horrible, came to dominate the Supreme Court oral arguments. So the Democrats and the supporters of the law countered that it's not a form of economic inactivity not to buy health insurance. All of us will become sick at some point in our lives, and therefore it's just a question not of if we buy insurance, but when. Do we wait until just before we're sick and purchase health insurance at that point, or do we throw ourselves on emergency room care without insurance? In either event, the decision to delay the purchase of insurance raises the premiums of all Americans, according to Congress, $1,000 a month. So that is why the government insisted that this was quintessentially economic activity. Well, how did the Supreme Court decide this case? We now know from some reporting by journalists, including Jan Crawford of CBS News, that when the decision was first discussed, 5 conservatives, including Chief Justice Roberts, voted to strike down the mandate under Congress's power to regulate interstate commerce. And this led Chief Justice Roberts to assign the decision about whether or not to uphold the mandate under the Commerce Clause power to Justice Anthony Kennedy, who was ready to draft a decision along these lines. But at some point in April or May, Chief Justice Roberts began to have second thoughts. And around that time, he switched his vote and decided that although he would vote to strike down the mandate under the Commerce power, he would vote to uphold it under the taxing power. And this created 5 votes to uphold the mandate. This infuriated the conservatives. There were unprecedented leaks from the Supreme Court, which seemed to have come from law clerks or people who talked to law clerks, where the conservatives accused Roberts of apostasy, of cowardice, of bending to political winds, of shifting his vote because he was afraid of criticism and pressure by liberal commentators and by President Obama. In my view, this characterization is unfair and inaccurate. When I go back and reread the interview with Chief Justice Roberts and carefully saw how repeatedly he talked about his ambition to persuade his colleagues to put the institutional interests of the court above their ideological agendas, I have to conclude that in this case, he did exactly what he said. He believed that it would be dangerous for the court's long-term legitimacy to be viewed as striking down such a central legislative act along party lines, and he thought it was more important to create an impression of bipartisanship than to pursue his own agenda at all costs. In this regard, he was very much acting in the spirit of his hero, John Marshall, who also would engage in what Marshall's arch-rival, Thomas Jefferson, called twistifications. It was a wonderful insult that Jefferson would hurl at Marshall. Marshall reciprocated by calling, Jefferson, Marshall reciprocated by calling Jefferson terrible insults as well, like the great Lama of the mountain. That's what he called Jefferson. It sounds terrible, but what does it mean to be a Lama? It's not clear what he's talking about. But they insulted each other, but when Jefferson talked about twistifications, he meant that Marshall would go up to the brink of confronting the president and then at the last minute come up with a clever legal argument that hadn't even occurred to any of the parties in order to avoid a confrontation in the short term and shore up judicial power in the long term. And that's just what Roberts did in this case. With this masterful and strategic decision, he's both increased his ability to vote with conservatives in cases he may care deeply about this term, including cases that will determine the future of affirmative action and of the Voting Rights Act. But at the same time, he has shored up his own bipartisan legitimacy and increased judicial power over the long term. So for me, this story of the great decision of John Roberts is a story that combines wisdom, a historical sense, a pragmatic concern about the court's legitimacy, and is very much in the spirit of Roberts' hero. But I'll be interested to hear in the question and answer whether you agree or whether you think that Roberts was being political rather than principled. All right, setting the stage that way, I now want to turn to these fascinating, crucial questions that are on the horizon about the future of technology and the Constitution. Will these be ones that divide along partisan lines, the way so many of the previous decisions have, or might the court, under Roberts' leadership, find some sort of bipartisan consensus? To try to persuade you how dramatic the stakes are when we think about the future of technology in the Constitution, I want you to imagine a hypothetical example, which in a few years will not be so hypothetical at all. Just a few years ago, in 2007, I was at Google, and a head of public policy at Google said he expected, within just a few years, Google and Facebook would be asked to put live and online all of the public and private surveillance cameras that now blanket the globe. So there are already some apps along these lines. On Facebook, you can sign on and look at an app of live beach cameras in Mexico, which are popular with teenage boys for reasons you can imagine. So imagine that the live beach cams in Mexico are joined to the subway cams in Washington, D.C., which are joined to the mall cams in London, and all of these images are linked and archived. In this world, it would be possible to sign on to Google or Facebook, click on a picture of anyone, say me, back-click on me to see where I came from this morning, forward-click on me to see where I'm going after this talk, and basically have 24/7 surveillance of anyone in the entire world. If Google or Facebook were to implement this system, would it violate the Constitution? In particular, would it violate the Fourth Amendment, which says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated? Well, the first challenge we face in asking whether this system, let's call it open planet, because Mark Zuckerberg might give it a name like that and say, sign on to Open Planet, it's really cool, you can check in on your friends, do stuff, however you call it. Would this Open Planet system violate the Fourth Amendment? And the first problem we have is that Facebook and Google are not the government. And the Fourth Amendment only binds the government. It doesn't bind Facebook or Google or other private corporations. The First Amendment only binds the government and not Facebook or Google. So you might well say, that Facebook and Google can do all the surveillance systems they want without raising any constitutional concerns at all. But let's not end this inquiry here. Well, imagine that the government is combining government-owned cameras with private cameras and is using this Open Planet system to track terrorists on Open Planet, and FBI agents are basically following around suspects 24/7 from door to door. Then maybe the Fourth Amendment might apply. But we still have a bunch of barriers to the possibility of a Fourth Amendment regulation. The court has held repeatedly that when I'm in public, I assume the risk that my movements may be tracked. This is called the knowing exposure doctrine. And the court says, for example, when I put out my trash, I have to assume the risk that the cops are going through it because I voluntarily surrendered all expectation of privacy in my trash. And they've also said that the police have the right to follow a suspect for 100 miles because we all have to assume the risk that our neighbors are tracking us or the police are tracking us for 100 miles. That's something that any member of the public has to expect. But surveillance on Open Planet, 24/7 surveillance, seems much more intrusive than just being followed for 100 miles. Would the Fourth Amendment have anything to say about that? Well, as it happens, in last year's remarkable Supreme Court term, the Supreme Court decided a case that casts a lot of light on the constitutionality of Open Planet. And I'm going to tell you about the facts of the case and tell you what the Supreme Court decided. This case was called United States versus Jones, and it involved a drug dealer who was suspected of dealing drugs in Washington, D.C. And the cops installed a GPS device, a local positioning system device, on the bottom of his car and tracked his movements 24/7 for a month. Based on this GPS surveillance, they concluded that he was indeed dealing drugs, and he was indicted and convicted. He then appealed. He said that evidence of his movements in public should be excluded and his conviction should be overturned because the police did not have a valid warrant when they put the device on the bottom of his car. In fact, they had sought a warrant, but it was supposed to be executed within 10 days. In fact, they started tracking him on the 11th day. It was supposed to only track him in the District of Columbia, but in fact, they tracked him in Maryland as well. So for the purposes of the case, the court had to assume that there was no valid warrant. And the Obama administration made this even more stark and dramatic by taking the very aggressive position that no warrant is ever required for any kind of surveillance in public because we have no expectation of privacy in public. Just as the neighbors and the police can track us for 100 miles, said the Solicitor General, so we have to assume the risk that we're being tracked 24/7 for a month. Lower courts have divided about this question, and in a historic decision, as important in its way as the Affordable Care Act decision, the Supreme Court, 9-0, rejected the position of the Obama administration and held that we do have an expectation of privacy in public. And they held that this was indeed a search and therefore was regulated by the Constitution. 9-0, Republicans and Democrats. A remarkable example of just what John Roberts said he wanted to achieve when he pledged to avoid partisan divisions. On the other hand, the justices divided in very interesting and surprising ways about the reason for regulating GPS surveillance. 5 justices, led by Justice Antonin Scalia, said the problem was that there was a physical trespass on the suspect's property when the police affixed the device on the bottom of his car. The car was parked in his driveway, they had to trespass on private property, and the seizure of his car for the purpose of gathering information, said Scalia, was a search because at the time of the framing of the U.S. Constitution, any physical trespass or interference with property interest for the purpose of gathering information would have been considered a search. In a remarkable concurring opinion, Justice Samuel Alito disagreed with Scalia's focus on physical trespass. Alito ridiculed the idea that it was important that the cops had physically attached the device to the bottom of the car. After all, said Alito, they could have gotten the same geolocational advice by subpoenaing the LoJack device embedded in his car. Or if he had a GPS device that was embedded in the car, as many new cars have, then they wouldn't have to affix a device, they could just go to the GPS company and subpoena the geolocational records which are stored in third-party servers in the digital cloud, that is distributed servers owned by Google and Yahoo and so forth. Or even more directly, all of us tonight, most of us, are probably carrying around GPS trackers with us. All of our cell phones have embedded GPS devices, and if the government wanted to reconstruct my movements over the course of today, it could subpoena my geolocational records from AT&T and could reconstruct my movements. And don't have any doubt about how comprehensive the picture of us that emerges could be. A member of the German Green Party, Malta Spitz, demanded, based under Germany's freedom of information laws, his cell phone records. He was able to create a three-dimensional graph that basically tracked his movements over the course of a month. So for all these reasons, Justice Alito said it makes no sense to focus on physical trespass. Instead, Alito proposed a more pragmatic test. He said, we do have an expectation of privacy in the whole of our movements for a month because geolocational tracking can reveal so much about us. The political rallies we attend, the friends we associate with, the magazines we read. A tremendous amount of information can be discerned by month-long tracking. Therefore, Alito said, if you're going to track someone for a month, please do need a warrant. If it's only a day, they don't. And the precise moment at which a warrant was required, Alito said, didn't have to be specified in this case. This provoked a remarkable debate between Scalia and Alito about what the framers of the Constitution would have thought about this. Alito was silly to try to imagine what James Madison would have thought of GPS tracking, because there was no GPS tracking at the time of the framing. Scalia said yes, but at the time of the framing, you could have a constable hidden in a carriage who was secretly listening to conversation. And Alito shot back, well, since you need basically 1,000 constables to track someone for a month, it would have to be very small constables or a very large carriage. Because in practice, it's impossible to achieve blanket surveillance of people using physical tracking. The technology greatly enhances the ease of the information that's collected. So this was the debate that went on, and then finally there was a really interesting concurring opinion by Justice Sonia Sotomayor. She said the court might have to re-examine the whole idea that when I surrender information to a third party for one purpose, I abandon all expectation of privacy in it for all purposes. That's called the third party doctrine. And in an age when most of us store our private papers and effects, not in locked desk drawers, but in the digital cloud, the third party doctrine means that we have less privacy protections for our private papers and electronic emails and documents that the framers of the Constitution took for granted. So you just see what a rich and fascinating debate is taking place among the justices. Let's try to apply the lessons of the Jones case to Open Planet. Well, if you agree with the Scalia justices, you say the government can track me on Open Planet because there's no need for physical trespass to track my movements. Google and Yahoo are using their own cameras, or government cameras with consent, and because they're not physically affixing GPS devices to me, there's no trespass and no search. But if you take the Alito position, that I do have an expectation of privacy in the whole of my movements, you might say a warrant is required. Still, even the Alito position presumed that I have an expectation of privacy because no one in practice expects to be tracked 24/7. But if Mark Zuckerberg were announced tomorrow, Facebook is starting up Open Planet, citizens get used to it. That would reduce my expectation of privacy and therefore my constitutional protections would be reduced. And in an age when surveillance is increasingly going to take place not based on old technology GPS devices, but on cameras mounted on tiny drones flying through the air, it might well be the case sooner rather than later that we do expect to be tracked by cameras in public. That means that if we're going to preserve just as much privacy in the 21st century as the framers took for granted in the 18th, we have to ask not only what do citizens subjectively expect, but what should citizens in a free society demand? How much privacy is necessary to live spontaneously and freely in a liberal democracy? And that's a question that can't be answered by asking what people actually expect. It requires judges to make hard judgments about what privacy can't be reduced without threatening our values as a democracy. If the Supreme Court were to confront Open Planet, would it restrict it? I don't know. It's not a liberal-conservative split, but justices like Scalia are reluctant to empower judges to make subjective decisions about protecting privacy. Perhaps Roberts, pursuing his bipartisan vision, could persuade the court to rule narrowly rather than broadly. But it would be foolish, though, to expect the future of privacy to be shaped entirely by the courts. The great advances for privacy in the 20th century often came not from courts, but from legislators. Congress passed laws regulating wiretapping and telephone surveillance and email privacy. And in fact, right now, there are bills pending in Congress that would protect geolocational privacy and prohibit the government from accessing my geolocational data from the cell phone companies without a warrant. The problem is, these bills have bipartisan support. The geolocational privacy bill is co-sponsored by Josh Chapitz, a Utah Libertarian Republican, and Ron Wyden, the Oregon Democrat. But civil libertarian liberals and libertarian conservatives are a minority in this country, maybe 20% according to some estimates, and mainstream Republicans and Democrats, ranging from the Obama administration to the George W. Bush administration, have opposed these geolocational privacy bills. So for that reason, the idea that the Congress could protect our privacy in the future is a theoretical possibility that may be hard to achieve in practice. That leaves one final way of protecting privacy in an age when Google and Facebook determine so much about the future of civil liberties, and that is political activism. The great advances for privacy in the 20th century came after mobilized citizens rose up to demand privacy. And I want to close this part of the talk by giving you an optimistic success story of sorts about how political activism can protect privacy and lead to the choice of good technologies rather than bad ones. This is the story of the choice between the naked machine and the blob machine. The naked machine, as we know, are those three-dimensional millimeter wave machines that many of us have to go through at the airport as a form of security. And they show contraband or plastics or any object concealed under clothing, but they also show graphic images of the naked body. Now, as it turns out, these naked machines did not have to be designed in this humiliating way. The original designers at the Pacific Northwest Laboratories, as early as 2004, offered the government an alternative. Call it the blob machine, because that's what it was. It still could reveal foreign objects concealed under clothing, but it scrambled the image of the naked body into a nondescript blob, and then would have an arrow pointing to the place on the blob-like avatar where the secondary screening was necessary. Well, this wonderful alternative, the blob machine, as opposed to the naked machine, is for most of us an act of mercy, better to be a blob than to be naked at the airport. But even more important, it's a silver bullet technology. It protects just as much security, but one technology threatens privacy and the other protects it. Given the choice between the naked machine and the blob machine, I would have thought that this was a no-brainer. And in fact, the few European airports that adopted this technology all insisted on the blob machine for reasons of privacy. Schiphol Airport in Amsterdam, for example, has blob machines. Now, as it happens, most European airports refuse to implement any version of this technology because of extensive evidence that it doesn't work, that it would not have detected, for example, the low-density contraband that the so-called Christmas trouser bomber tried to use a few years ago. But if you are going to have it, you'd think that the choice would be simple, blob over naked machine. But that's not what happened. First the Bush administration and then the Obama administration implemented the naked machine technology and refused to back down. It took a political protest, energized by the Patrick Henry of the anti-body scanner movement, that heroic guy who exclaimed last year the equivalent of, "Don't touch my junk." That guy inspired a political protest. Travelers across the country rose up at Thanksgiving and refused to go through these machines. And then President Obama told the Homeland Security Department to go back to the drawing board and And they were shocked to discover that they could, in fact, retrofit about half the machines in the country with a lot of machine learning technology. I'm not sure I can see this morning which technology is here in Des Moines, but if you go through, whether here or nearby, in Chicago they have the naked machine technologies with those awful skeletal pictures, just know that that was completely unnecessary violation of privacy, and with a little more thoughtfulness, the machines could have been better designed. But I think for me, I want to end on this hopeful note. It is possible to design technologies that protect liberty and security at the same time. It requires a combination of enlightened judicial decisions, such as the Jones decision, which displayed the bipartisanship that Roberts had pledged to achieve, of legislative regulation, but also, ultimately, of political activism, of engaged citizens rising up and demanding technologies that protect liberty and privacy. So I want to challenge you, encourage you to remain engaged in these fascinating issues, learn about their dimensions, and recognize that the future of the Constitution will not be determined exclusively by courts, as important as Chief Justice Roberts' decision was. Courts can't save the Constitution, legislators can't save it, technologists can't save it. Ultimately, the shape of constitutional values in the 21st century will be determined by engaged and active citizens right here. Thanks so much. I'd love to have a conversation about these interesting issues. Thank you.
Questions from the audience. We do not have the microphone to run around tonight, so I will ask if you ask a question, please stand, please speak clearly, enunciate clearly, so that everyone can hear your question, so that we don't have to repeat it to the audience. So, anyone?
Remember, I'm a law professor, so I can call out people. Yes, sir.
If the worldview were to happen and it were ruled that it's constitutional for Facebook to follow me wherever, could the government buy that information constitutionally?
Great question, and the answer is yes. Basically, if Facebook legally obtains the data, then the government can obtain it as well. And even right now, you don't need a judicial ruling to allow the government to piggyback off of Facebook data. Facebook collects a huge amount of information already, and all of that is considered information which surrendered expectation of privacy, and which the government can certainly get with a subpoena, no question about it, but might even be able to get without some kind of judicial order on the grounds that it's public, regardless of your privacy settings. Now, Europe does not have the same view. In Europe, some countries have made it illegal for employers, for example, to force you to open up your Facebook during a job interview and reveal private data. And they've also severely restricted government access to data held by third companies. I told you that we have this thing called the third-party doctrine that says that if I surrender information to Facebook for one purpose, I've abandoned all expectation of privacy in it for all purposes. Europe holds the opposite. They say information surrendered for one purpose may not be disclosed for another purpose without the consent of the individual concerned. So that really shows how much more protective Europe is of data gathered by the private sector. Surprisingly, they give government more power of surveillance than we do. So we tend to restrict the government and not the private sector. They're the opposite. They restrict the private sector but not the government. But as your excellent question suggests, this is not good for privacy because whoever is not restricted can get the same data from the other market. So basically, I think this all has to be re-examined, and at some point, if the Supreme Court considers the constitutionality of cell phone data, for example, it might say that the fact that you turn it over to the phone company, or the fact that you surrender something to Facebook, doesn't mean that Facebook can turn all of it over to them. You've identified a real dilemma here. Privacy. Yes?
You seem to be pretty positive about Roberts and the fact that he was considering the long-term impact on the court in his decision. But it seems to me that's a pretty subjective standard. Anyone could argue that they're looking out for the long-term interest of the court. And And so I'm wondering how you defend that in light of the fact that that's really a plea to a perception about public opinion and not a rationale that's actually based on the law.
It's a very good challenge, and you've well articulated, there's the strong objection to what Roberts did and the view that I was defending. You're basically saying that it's the job of judges to interpret the Constitution, not to read the polls. And their job is to think about long-term legitimacy. It's just to do whatever the law requires and never mind the consequences. And that's a view that Justice Scalia has articulated very forcefully. And the conservative justices have made pretty clear in their, or at least their courts have in the chatter, that they think that Roberts was being unprincipled, being political, when he put the institutional interests of the court above what the law required. What's my answer? Why do I admire Roberts' vision? Well, first of all, the longer I teach constitutional law, the more suspicious I am of claims that the answers are clear in any of these cases. Whenever anyone tells me that, I reach for my wallet. The truth is there are very strong arguments on both sides of these cases. For me, a sense of humility and of judicial modesty leads judges generally to defer to the elected legislature unless the arguments for invalidation are overwhelmingly clear and convincing. And the arguments in this healthcare case seem to me that were novel enough that the presumption of deference might not have bear that. But we can debate this extensively, and you may not be persuaded by the way I see the law. I still respect what Roberts did because for him, the role of the Chief Justice is different than that of the Associate Justice. I think if he had just been Justice Roberts, as he was first nominated to be, rather than Chief Justice, he almost certainly would have voted to strike down the matter. But for him, the Chief Justice has a unique stewardship of the court as an institution in American democracy. It's not supposed to read the polls. And interestingly, that's not what he did in this case. Remember, right before the decision, polls were pretty strongly against the mandate. Democrats and Republicans, some polls suggested 70% wanted the court to strike down the mandate. So whatever Roberts was doing, he wasn't just reading the polls and thinking, this is popular, so I'm going to uphold it. I think what he was doing is exactly what he said in this interview. He was putting the court's institutional interests first, thinking that public legitimacy that the court relies on is a fragile thing. And once the court loses it, it may find it more difficult to enforce its commands in the future. And I think Roberts might have been thinking of cases like Brown versus Board of Education, where the court decided to allow its mandate to be implemented slowly rather than immediately because it feared that there would be massive resistance in the South and that the court's authority would be in peril. And once again, you can challenge this vision and say the court in Brown versus Board of Education shouldn't have been sensitive to its legitimacy. Or to take another current example where legitimacy interests might trump your view of the correctness of the law. Let's say you're a justice who believes that the Constitution protects the right to gay marriage. But you think at the moment, the country is narrowly divided about this, there might be great resistance to such a ruling. A decision recognizing a national right to gay marriage right now might provoke constitutional amendments in the states, just the way the Massachusetts gay marriage decision provoked 13 states to pass amendments banning gay marriage. So you think better to wait. This term, the court will decide whether to hear the California case, which recognized the right to gay marriage. And if you're a justice who believes in that right, you might think the court just waits even 5 years. The polls suggest there's a huge generation gap here. You, ladies and gentlemen, are likely to be much more pro-gay marriage than older generations are. Both liberal and conservative people are pro-gay marriage. So within 5 years, the country wouldn't have a backlash, but now it might. So you vote not to hear the case because you care about the court's legitimacy. All right, well, is that appropriate? In the meantime, for 5 years, a lot of people who love each other won't be able to get married. The analogy here is interracial marriage. This is exactly what happened after the Brown decision in 1954. It was immediately obvious if separately schools are unconstitutional, so were the laws in many states, including Virginia, that forbade black and white people who loved each other from getting married. Both were based on a premise of African-American inferiority, which violated the Constitution. And yet the court, for 13 years, between 1954 and 1967, refused to hear cases raising the constitutionality of interracial marriage because the justices feared a backlash. They thought their legitimacy was in peril. They weren't just reading the polls. It wasn't quite that crude, but they thought really that the whole effort to dismantle segregation will be imperiled unless the court waived. And it wasn't until 1967 that those interracial marriage bans were finally struck down. Just because I've given this example, you raised an important question. Do you think the court was right to wait those 13 years, or should it have struck down those interracial marriage bans in 1954, even if the decision would have been ignored or massively resisted?
You know, I think what I was getting at is maybe not even so much public opinion, but this seems to be a very specific segment of public opinion. The argument that some in the mainstream media or legal scholars would have a bad opinion inside of the other side. It just seems to me you have to stand on the strength of your reasoning, and he seems to have tried to do that by separating out the idea of commerce clause and taxation. But it ended up looking like, and people were inferring that there was some other motive to this decision, because that seemed not the strongest rationale.
Okay, you're absolutely right that this is what conservative commentators charged. And this sort of struck home because George Will, right around the time when Roberts apparently switched his vote, wrote a decision saying that Roberts was being intimidated by liberal commentators, including, as it happens to me, because I've written a piece for the New Republic saying, here Roberts gave his interview in 2006 where he pledged to avoid partisan splits. I hope he does the right thing, because if he strikes down the healthcare mandate on a 5-4 vote, he will have failed in his stated effort to avoid striking laws down on 5-4 votes. I thought it was just stating the obvious by recalling what Roberts had said he would do. But Will and other conservatives interpreted this as intimidation, and after the fact, accused Roberts of bending to the will of liberal commentators who wanting to be well thought of in Georgetown. I think this is just nonsense. You can't possibly read that interview, which Roberts gave in 2006, or you can't have sat down with him as I did. I mean, I may not be the sharpest judge of character, but I don't think that someone can elaborately over 3 hours just completely be deceitful when they say, this is my earnest hope, I want my entire Chief Justiceship to turn on my ability to be like John Marshall and avoid partisan splits. So I don't think it had anything to do with bending to, he doesn't care what I think or what any commentator thinks. He cares a lot about his legacy, no question about that. And in this sense, he's painted in all sorts of terms, but I think there are surprising similarities between Chief Justice Roberts and President Obama. Some of the similarities are obvious, both raised in Chicago and its environment, both Harvard Law graduates, incredibly charming, very, extremely intelligent. But both came to Washington sort of pledging to overcome the partisan divisions, and I think both found that those divisions were more entrenched than they expected. Both thought that they could overcome those divisions by force of charm or personality, and in the end, they found that there was much less appetite for compromise than they expected. So all this is to say, I think John Roberts has much more important things on his mind, much larger ambitions than being well thought of by newspaper columnists who I'm sure is quite indifferent to. He really wants to make a mark as Chief Justice. He even said, more than half of my predecessors as Chief Justice have been failures. He was reading biographies of the most successful Chief Justices over that summer. He's measuring himself by those historic standards. And that's why I think he merely was doing what he said he did. We could talk more about this. I think your question helpfully illuminates, first of all, a legitimate debate about the appropriate role of the Chief Justice and an Associate Justice, and also this delicate line between public opinion on the one hand, which you don't want the court to slavishly follow, and institutional legitimacy, which maybe the court should follow, and whether it should or not, it generally has. And if you look at Supreme Court decisions over the course of history, you'll find that most of them have tended to track the broad constitutional views of the public, and on the rare occasions when the court has handed down a decision which the public actively contests or resists, there's often been a backlash that's harmed the court and the cause that it's trying to protect. So just a handful of examples like this. The last one may have been in the 1930s when the court struck down the centerpiece of Franklin Roosevelt's economic agenda, provoking the court packing plan, where President Roosevelt pledged to pack the court with justices sympathetic to his views. And the court packing plan went down to defeat, but in the famous switch in time that saved 9, the Justice Roberts, as it happened, although no relation, Owen Roberts, switched his vote and began to uphold the New Deal. So that just shows us descriptively, whether you think that's a good thing or not, that the court has tended to be sensitive to the give and take of its role vis-a-vis the other branches of government. And on the times when it really challenges the president or Congress on things they care a lot about, it often provokes backlashes. There's more to say, but thank you for introducing those important considerations. Yes,
many Americans think that we enjoy a right to privacy, but the Constitution doesn't actually guarantee any such right. Do you think that an amendment or something to that effect is needed and would be useful? And are there any efforts underway to create such a need?
Great question. You're absolutely right. The Constitution doesn't contain the word privacy. It protects privacy in various provisions. The Fourth Amendment, as we talked about, protects us against unreasonable searches and seizures. The Third Amendment prohibits soldiers from being quartered in the home. The Fifth Amendment prohibits me from being compelled to testify against myself, and they protect the zone of mental privacy. But there's no right to privacy that might, for example, protect my privacy on the internet. So what's one right that Americans really care a lot about that they might possibly mobilize around to pass a privacy amendment? I would think it has something to do with the ability to control your image on the internet. So, for example, lots of us know people or hear great stories of people who have lost jobs or been fired or not promoted because of embarrassing Facebook pictures. And there's a famous story of Stacy Snyder, who was a 22-year-old teacher in Pennsylvania who went on to MySpace wearing a pirate's hat, drinking from a plastic cup, and it had the caption, "Drunken Pirate." So her supervisors at the teacher's college said that she was promoting underage drinking, and they fired her. And she sued and basically said it was private activity and should be protected. And a judge rejected the claim based on, just as you suggested, the fact that there's no right to privacy, and also her comments were not protected by the First Amendment. So could you imagine a constitutional amendment that would protect a right to escape your past on the internet? Well, it seems almost fanciful in America, but as it happens in Europe, precisely this right is being proposed as we speak. It's a remarkable new right, and it's called the right to be forgotten. And we talked about it in the class earlier today, but it's being proposed by the French. It comes from French law. It's called the droit à l'oubli, or the right of oblivion. It's very French, the idea of sort of existential elimination. But under this right to be forgotten, if you object to anything that's posted about you on the internet, either a picture you posted of yourself, or a picture you posted yourself that's been widely shared by others, or even just some comment about you as a data subject that you disapprove of, you can demand that it be taken down. And Google or Facebook or whoever will be required to take it down under this right, unless it's necessary for journalistic, scientific, or literary purposes, as determined either by Google and Yahoo or by the European Privacy Commission. And if Google and Yahoo don't take it down, then they can be liable for 1% of their annual income, which in Google's case is $40 billion, creating a very strong incentive to take stuff down. Now, you ask, should there be a constitutional right to be forgotten along those lines? Here, I find a clash between my privacy instincts, which are strong, and my First Amendment instincts, which are also strong, in this case, I think, trump. So I worry about the ability of people selectively to delete themselves from the internet. And there's a dramatic case here in Argentina, where an Argentinian pop star posed for racy pictures of herself, as pop stars do. They kind of went viral, and she demanded that Google and Yahoo take these pictures down, stop linking to these thousands of versions of the picture. Yahoo said, we can't do it. It's too hard to identify just these racy pictures. An Argentinian judge fined Yahoo lots of money per day. Yahoo said, okay, we can't just take down the racy pictures. We're going to remove all references to this woman from the Yahoo search engine. So if you plug her name, Virginia Tapuna, into Google, into Yahoo Argentina, you get a blank page in a judicial order saying all reference to this person has been removed pending litigation. You know, I think that ability to completely remove yourself from public discourse, to delete your past, is not consistent with the American tradition that says that truthful but embarrassing information can't be restricted and might be very relevant to public discourse. What if the pop star were running for parliament the way Italian pop stars tend to do after they vote for race Christians and so on? Basically, though, this is a really legitimate debate. It's a very deep question. I think it looks like some version of this European right is about to be implemented, possibly raising dramatic challenges for those lawyers at Google and Yahoo to determine on a case-by-case basis what to take down, what to leave up. It becomes even more complicated because Google, as we saw last week, has the ability to block pictures in some jurisdictions but not others. So it can decide to block the pictures just for users with an Argentinian IP address but not elsewhere. But then there might be further demands to remove it across the globe, and there could be international dimensions. It's just the complexity of the issue is so great that we're seeing an old European tradition which very strongly protected the dignity of the individual, but didn't tend to enforce that right very vigorously, clashing with the technological powers of the internet. So it's a long answer to an important question to say, can I imagine a right to privacy being proposed? In theory, but I think in practice, Americans disagree so much about exactly what the scope of the right should be. When you say the right to privacy, are you really talking about the right of reproductive choice? One dimension of privacy, which some people fervently support and others strongly oppose. Are you talking about a right of reputation on the internet? Well, there, sounds good, but there are these free speech interests on the other side. Are you talking about a right against surveillance in public? Well, that might be something that, mobilized majorities of the country could get around, saying the government can't track you 24/7 without a warrant. Well, that sounds like a good constitutional amendment, except here this geolocational privacy bill, which would essentially achieve the same thing, can't even get reported out of the Congress, let alone the supermajorities necessary to be proposed to ratify the constitutional amendment. So privacy, my favorite topic, is something which lots of people support in theory but disagree a lot about in practice. To pass constitutional amendments, you tend to need galvanizing events. The Civil War, it took a Civil War to pass the constitutional protection for equal protection of the laws, for the women's rights movement, culminating in the 19th Amendment, giving women the right to vote. But you need almost, a generation of activism on behalf of privacy before it could be codified in an amendment, which brings me back to that point about the blob machine and the naked machine, that before it's appropriate to propose an amendment, you want to really mobilize national consensus around it and get a lot of bipartisan support and so forth. That's my instinct.
And this actually kind of dovetails on that. I think it's kind of a little bit broader question too. You started with, and kind of came back to this, the sort of the power and influence of Google's lawyers, right, and sort of quote communications. As you also pointed out, though, and as Google's lawyers would tell you, the reason that they blocked access to certain parts of the world for this video was because they were doing so, and I don't know if this is just their cover or if this is legitimate explanation, but it was because of local laws. They were trying to not run afoul of local laws. What about that sort of influence, and sort of what about, I suppose, does Google, legally speaking, is it sort of as powerful and influential an institution as, say, the Chinese government or the Egyptian government?
Okay, so this is a great question. I don't know if you all heard all of it, but the question is Google lawyers as powerful as the Chinese government and the Egyptian government, and is Google just engaging in a cover when it says that it's going to obey local laws but won't go beyond that? I don't think Google is engaging in a cover, and I think its lawyers are grappling with some very difficult and challenging lines. So in 2008, I met the woman who at the time was in charge of free speech for Google. Her colleagues called her the decider, because she was the ultimate person who decided when a video came down or stayed up. And her name is Nicole Wong. She's since left the company. But she would get calls in the middle of the night from the Thai government, which said that YouTube videos insulting the king by showing him with his feet on his head, which is a big insult in Thailand, violate local laws against insulting the king. And Wong doesn't speak Thai, but if she concluded it did violate that Thai anti-defamation law, it would come down. But maybe it was a tough case. It wasn't just insulting the king, but insulting the political party sympathetic to the king, in which case she would leave it up. So she was trying to balance protecting as much speech as possible with the need to obey local law, which was established in a decision involving Yahoo and Holocaust denial material where Yahoo initially claimed we don't have to obey the French law prohibiting Holocaust denial, and a French judge said, oh yeah, we're going to fine you lots of euros a day unless you take it down. Yahoo said, okay, you win, we will obey local laws as long as they're clear. But that just creates so many difficult gray areas where it's not obvious whether the local law is being violated. So there was a case of Greek football fans posting YouTube videos saying that Kemal Atatürk, the founder of modern Turkey, is gay, which Greek football fans love to do, just taunt their Turkish rivals. And that's illegal in Turkey to insult Turkishness and Atatürk. But once again, Wong had to decide whether it was really an insult against Turkishness or an insult against the ruling party. So Wong decided if he did insult Atatürk, it was illegal, but she only wanted to block the video in Turkey. That wasn't enough for the Turkish government. They said you have to block this around the world because anyone might see these terrible videos. She refused to block around the world, and as a result, the Turkish government retaliated by completely blocking access to YouTube in Turkey. So it shows the back and forth, the give and take among the government and Google. In this case, the Egyptian video case, the YouTube community guidelines are what's at issue. YouTube enforces its guidelines. Ultimately, Wong was the decider. But initially, individual users can flag a video as being inappropriate, and first responders at YouTube decide whether or not the community guidelines are violated. So I also got to see these first responders. They're a bunch of, 27-year-olds in flip-flops and t-shirts sitting in San Bernardino at the YouTube headquarters looking at laptops, often with porn flickering on it, because that's the main YouTube flags they get, where someone objects that the video is pornographic and violates the obscenity guidelines. And these young people have to make spot decisions on whether the guidelines are violated. If they're not sure, they'll escalate up, and Wong makes the final decision. So here it's a very tough line to draw. The YouTube guidelines prohibit insulting people, the Muslim people, but allow the insult of a religion apparently. And figuring out whether this Muhammad video was an insult against the Muslim people, which Google determined it wasn't, as opposed to insulting a religion, which it was, is again a tough call. Then you ask the really tough and important question, is who's more powerful, Google or the Chinese government or the Egyptian government? Well, Google is extremely powerful, and we saw in this case, Google was more powerful than the US government because the Obama administration requested that Google take down the videos everywhere. And Google refused. It rebuffed the administration's request and said, we'll take it down in Egypt and Syria because we think that imminent violence is threatened. We'll take it down in India because it's clearly a violation of local law. But we will not take it down everywhere else. Well, we learned today in Professor Sutton's class that Saudi Arabia has just blocked access to the videos on their own. So that suggests that Google may have the power to ignore the requests of democratic and free governments, but it may be powerless before the autocratic governments that literally try to shut Google down, as Egypt did during the Arab Spring when the Mubarak government flipped the internet switch. The Egyptian networks are distributed in a way that there are a few central nodes, and they basically turned off access to the internet for a time, making a mockery of the claim that information is completely free and that Google by itself will determine all these things. So what does this suggest? The future of free speech is A, extremely interesting, and B, extraordinarily complicated, and that it's a complicated negotiation between private lawyers at these internet service providers, democracies, dictatorships. It's a constant give and take. Every move by one party will be met by a counter move by another party. One thing that's clear, it is not enough if you care about the future of the Constitution to do what I did when I went to law school, a while ago, and that's just read Supreme Court decisions. Because whatever Justice John Roberts says about the First Amendment, at the moment it's going to be far less important than what Nicole Wong and the Turkish government say. Yes.
You talked a little bit about the Great Depression court cases and NPR court cases. Of course, those parallels have been made all here with the Obama administration. It seems like the ideological differences of those times were solved by one political group undercutting and threatening the other, and the Supreme Court more or less acquiescing. Do you believe that's how our ideological differences are going to be solved now? And do you think that that's the right way to go, or are there other alternatives?
That's another good question. It's true that the main reason that the court acquiesced in 1937 wasn't because Roosevelt threatened to pack the court, but because he won a landslide election, the largest landslide in recent history, and public opinion was mobilized in favor of the New Deal, and the court concluded accurately that it was powerless to impose a pre-New Deal vision of the Commerce Clause on a mobilized country. Will that happen now? It doesn't seem likely. This country is far more ideologically divided and polarized than at the time of the New Deal, where supermajorities supported the Rooseveltian vision. Even in the case of the healthcare mandate, as the poll showed, there were plenty of Democrats who had doubts about it, so there was hardly a groundswell of support for it. And whatever John Roberts was doing was not simply reading the polls and bowing to the mobilized wishes of the American public. Now, would you ask, what about the future of Congress's power to regulate interstate commerce? And who will resolve this now active dispute we have about whether there are strong constitutional limits on Congress's power to regulate the economy? This is the kind of hidden drama of the healthcare case. Yes, Roberts cast the vote to uphold healthcare reform, but he joined the four other conservatives in embracing a much more limited vision of Congress's power to regulate interstate commerce that the liberal justices, led by Justice Ruth Bader Ginsburg, who had quite a fiery dissent on the question, suggested would call into question lots of regulations in the future, including environmental regulations, health and safety laws, plenty of food and drug laws, all of which might not substantially affect interstate commerce. How will this be resolved? Of course I don't know. And we'll see whether this will be another test of John Roberts' leadership to see whether he means progressively suppress this narrow vision of the Commerce Clause in the face of both strong liberal dissent and great contestation in the country as a whole. One thing that's clear is whatever political support there is for this narrow vision of interstate commerce, it's not any larger than the Democratic position on the other side. Tea Party Republicans want to dramatically reduce the scope of the federal government, and justices like Clarence Thomas, in their opinions, have said that they want to go back to a pre-New Deal understanding of the Commerce Clause and dramatically to prohibit the kind of things and activities that Congress can regulate. But until the healthcare case, no mainstream conservative justices or politicians had embraced that vision too. That's why it was something of a surprise to see not only Justice Roberts and Alito, but Justice Scalia, who had previously taken a much broader view of Congress's power to regulate interstate commerce, joining, all four of them, or five of them joining in this new vision. So this will be a great drama, the term ahead and the years ahead, to see whether this legal movement, which some have described as an effort to resurrect the Constitution in exile, referring to doctrinal limits on Congress's power that have been dormant since the New Deal, will these limits be aggressively enforced and expanded by the courts? What will really determine the future of it? Well, obviously, the presidential election. I mean, here we've gone through a whole talk about the Constitution without noting mistakes in this election, and this is a entirely bipartisan speech, so I'm not going to say anything more except for the fact that this election will determine the future of the Supreme Court. People have been saying that for the past couple of generations, a couple of elections. Liberals have been warning for 2 decades. Roe v. Wade is about to be overturned. Well, that was an exaggeration, because ever since 1992, Roe has been comfortably upheld by first a 6-3 and then a 5-4 vote. But with this election, if President Obama is reelected, he'll likely have the chance to replace at least one liberal justice, perhaps Justice Ruth Bader Ginsburg, with another liberal, and the balance of the court will be the same. If Mitt Romney wins, it's just as likely that he'll have a chance to replace a liberal justice with a conservative justice, creating a strong 6-3 majority in favor of possibly overturning Roe, but certainly dramatically narrowing the scope of Congress's power to regulate interstate commerce. And if that were to happen, then everything I said about Chief Justice John Roberts and his aspirations for bipartisanship might become moot, because he is happy to seek common ground when he's at the center of a relatively evenly divided court. But if he were to have a strong 6-3 conservative majority, no matter how much he cares about the court's legitimacy in theory, his incentive to compromise in practice might well evaporate. So that's why this election is very important. And you should vote not only on the basis of which candidate you find most compelling, but also which constitutional vision you find most compelling. And the two don't have to coincide. When I teach constitutional law, I love to begin the first day of class by saying, the one thing you're not allowed to do in this class is assume that it's all politics, that there's no difference between a justice's constitutional views and his or her political views. You may think that in some cases, on both sides, Roe v. Wade, Bush v. Gore, but if you assume in every case that all the justices are doing are voting their politics, then you're missing everything that is constraining and engaging and ultimately beautiful about the Constitution. And for me, that vision, that aspiration that it's possible to separate your constitutional from your political views was vindicated by Chief Justice Roberts' inspiring vote. He did precisely that. And he said that for him, his constitutional views trumped his ideological agenda. You can do the same thing. You might well, maybe you're someone who's sympathetic to Tea Party criticisms of federal power, but you don't think that judges should be judicial activists, and they shouldn't be second-guessing the choices of democratically elected legislatures. Or conversely, you might really support healthcare reform and like what President Obama is doing, but think that it's dangerous for the court to abandon all limits on Congress's power. I'm no longer interested in my own political views. Who cares? They're no more valid than anyone else's. And when it comes to the Constitution, I find myself less and less certain that there are right answers to these questions, but I feel most secure and most engaged when I reach a case where I know that although my policy views point one way, the Constitution requires the opposite. And I encourage you to try to test yourself by looking for those same components. Maybe if we do need to wrap up now, because I've delayed you long enough, I will end by urging you just to be engaged by these fascinating issues. You don't have to be a lawyer, or an aspiring lawyer, or even a recovering lawyer to care about the Constitution. You just have to be a citizen, which all of you are, and test yourself. Go to the Supreme Court website, supremecourt.gov, pick a case that interests you. You can go back and look at the healthcare arguments, or U.S. v. Jones, the GPS case from last year, or the affirmative action case from this year, which is going to be argued on October 10th, and will determine the future of affirmative action. Read the briefs, read the oral arguments before the court, and most important, read the opinion when it comes down. They're long. You don't have to read every word of it. There's a lot of legal jargon. Don't be intimidated by the legal jargon. In each of these cases, there are one or two basic principles that the justices are grappling with. I don't think there are clear right and wrong answers. You read the arguments and make up your own mind. It is one of the privileges that we have as American citizens, and it's been such a pleasure to discuss these issues with you on Constitution. Happy Constitution.